Hello friends, Namaskar. Myself is Dr.Jinesh Soni. I am an advocate and a corporate lawyer. Today in the present class I will discuss the nature of departmental action, specifically in the light of cases concerned with Prevention of Corruption Act. Do you know we are having multiple cases in which I inter alia observed that some of the departmental actions are barred by law, some of departmental actions are illegal, and some of them should not be initiated, but despite of that they are not only initiated but also adverse actions had been taken against charge official, resulted in a serious prejudice to his service and career. You might be one of the victims of a false departmental action or any action that is barred by law, but due to lack of knowledge or information on subject you are facing the same, and there is no one to help you on this concern. So, as far as my little knowledge is concerned, I am going to help you to understand the same in a very simple way. But for this, I request all of you to keep all the facts of your case in your mind and note down the same on a concerned notebook in a very simplified format. In the meanwhile, I am discussing some important points with you, and if you inter alia finds that you are having a resembling case, in that scenario, these legal points could be helpful to you. And apart from that, I request all of you to maintain the information which is narrated by me in the present class in the recorded format, means in your notebook, so that you could easily contest the issue without any worry or panic. So the first question we will discuss is that whether during the continuance of a case under Prevention of Corruption Act or departmental action would be justified or not. The answer is given to that query by Honorable Rajasthan High Court. Judgment title is Devendra Mehta versus Union of India. It is pronounced on 12th of Jan 2022. In that case, it is observed that during the pendency of a corruption case, departmental proceedings is required to be kept in abeyance. But the important point is that on similar facts, if the facts are not similar, in that scenario, the proceeding would not be barred. The same view is reiterated by Honorable Supreme Court in an important judgment titled as Union of India versus B.B. Gopinath. Citation is 2014 Volume 1 SCC page 351. So on point number 1 we are very much clear. Now I am coming on point number 2. Point is, if we are having a case under Prevention of Corruption Act, ultimately facts are similar in the departmental action, but we got acquitted in that corruption case, whether it would provide a benefit to us in said departmental action or not. The answer to that query is given by Honorable Jharkhand High Court in an important judgment titled as Rahul Kumar versus State of Jharkhand. Judgment is pronounced on 12th of August 2024 in that case. The prime attack of the concerned defense was that whatever facts are imposed in departmental action are similar to criminal case. In criminal case, I had been acquitted, but despite of that, no benefits are given. In course of argument, he submitted the facts. His submissions are that he joined services in the year of 2007. At that time, for a period of 2 years, he was on probation. Ultimately, during the continuance of the probation period, he was caught red-handed. The primary attack of concerned prosecution is that he demanded and accepted the bribe, and that's why he was caught by consent vigilance and finally charge sheeted, and that's why we had inter alia initiated the proceeding in nature of departmental action, because doing the act of corruption is against the norms, and that's why public servant is liable to be charged for violating the norms of department, and that's why he is liable to be prosecuted as per the norms. At the inception, there was a show cause notice, and finally memorandum of charge is served. Reply was submitted by the concerned charge official, but finally adverse action is taken on ground that the submissions of the concerned charge official is not found to be satisfactory. The prime attack of the consent defense is that the action taken by the consent authority is totally unjustified, because At the first point, he submitted that the consent case under Prevention of Corruption Act was false, and ultimately he was acquitted by the concerned special judge in that case. In addition to this, without examining any witnesses and without affording any opportunity of being heard to the concerned charge official, adverse action is taken and charges were said to be proved. The said approach is totally illegal and it violates the principle of natural justice, which says that hear both the parties before passing any order. In the counter, the state submitted that we are not bound to consider judgment of acquittal because it is not the honorable acquittal. They submitted that when the witnesses are turned hostile in that scenario, judgment could be said to be passed in absence of evidence and the prosecution totally failed to prove the case beyond reasonable doubt. But in case of honorable acquittal, the case is required to be contested on merits, which is not occurred in the present case. It is submitted by the concerned charge official that in the present proceedings, every action is motivated and ultimately it is taken to debar the concerned official from promotion. Ultimately, he submitted that the act is totally biased and inter alia it infringes Article 16 of Constitution of India. The state submitted that even though there is an acquittal in a criminal case, but it never bars a departmental action. Even though minor penalty is imposed, but it is discretion of the concerned department. Even though minor penalty is imposed, the name of the concerned employee could not be considered for the purpose of promotion. Inter alia, the concerned state relied on expression number 2, clause number 4, Rule 14 of Jharkhand Government Servant Classification, Control and Appeal Rules 2016. Thus, the concerned submission of the state is that the promotion of the concerned official, if declined, then the approach is not illegal and perverse. In the counter arguments, the concerned official submitted that the proceedings are illegal because no opportunity of being heard is given. And ultimately, defense relied on judgment of State Bank of India versus Narendra Kumar. Citation is 2013 Volume 2 SCC page 740. And apart from that, it is submitted that the concerned proceeding of acquittal had not been considered, which is totally perverse, and inter alia resulted in prejudice to the rights of the concerned charge official. So, in sum up, we could say that the attack of the concerned defense was that the charge sheet must be by the competent authority, which is not in the present case. He submitted that during the continuance of the case under Prevention of Corruption Act, the proceeding in nature of departmental action is to be kept in abeyance, which is not done in the present case. Opportunity of hearing must be given, which is not done in the present case. And apart from that, the fact of acquittal is to be considered, which is not done in the present case. And inter alia defense relied on judgment of GM Tark versus State of Gujarat. Judgment citation is 2006, Volume 5, SCC, page 446. He submitted that even though minor penalties are imposed, but the same cannot be a ground to cause impediment in promotion. So, the observation of Honorable Court is that the concerned authority is bound to follow the principle of natural justice, and apart from that, it is duty of the concerned prosecution, even in nature of departmental action, to prove the case. If the sustaining evidences are not on record in that scenario, the official could not be charged and punished as per norms. And apart from that, the adjudicating function exercised by inquiry officer is totally independent. In that scenario, the concerned authority is not the agent of government. The authority has to examine the evidences and has to find out the guilt. Apart from that, the approach should not be casual and against the norms. So, the court observed that as far as Article 311 subclause 2 of Constitution of India is concerned, it is not a casual practice. It entirely emphasizes that the concerned official must be heard, and apart from that, the order must be reasoned. So, on two important points, the judgment is set aside. So, if we are having the same resolving issue, we have to emphasize that whether opportunity of being heard is given to us or not, and apart from that, whether the alleged order is reasoned or not. If both the criteria are not fulfilled in that scenario, we may easily challenge the proceeding before Honorable High Court or before Tribunal while relying on these judgments. So I think that I am totally able to cause all of you to understand the two important points usually makes a trouble for all of you concerning departmental action, specifically when taken in case there is a case against you under Prevention of Corruption Act. So see you in the next video. Till then, Jai Hind, Jai Bharat.